Hello and welcome back. I'm James Wilson from Park Square Barristers in Leeds. This is a video about remote hearings and fundamental dishonesty and fraud. I've just done a video about the directions that are being handed out by Manchester Civil Justice Centre in relation to fast-track trials and doing those remotely. One of the potential exclusions are those where there are issues of fundamental dishonesty and fraud. So Manchester is saying if there's FD or if there's fraud, it's unlikely that that will be suitable for a remote trial. Now, we know, don't we, for those of us who work in this area, that it doesn't have to, fundamental dishonesty doesn't have to be pleaded, although fraud obviously does, but fundamental dishonesty doesn't have to be pleaded, even if it's an issue in the case. For example, low velocity impact, or cases where a claimant is simply put to proof and issues are raised with regards to their credibility or potential credibility at trial. On a slightly different note, it's not beyond the realms of possibility that normal liability trials can raise issues of fundamental dishonesty if the claimant has decided to give evidence which is substantially different to that which has been given in witness statements or to medical experts, etc., and is potentially be found to be fundamentally dishonest based solely on that claimant's evidence at trial, an issue which nobody could have predicted until the beginning of that person's evidence. So identifying a case where fundamental dishonesty might be an issue is a potential problem when courts are assessing whether a case is suitable for a remote hearing. Just on that point, my thoughts about it are these. There are different types of fundamental dishonesty cases, aren't there? Different types of cases where you are or might allege that the claimant or claimants have been dishonest, ranging from the top end, staged accident, conspiracy. Now, in those cases, there will be evidence before the litigators, before the trial begins, that these are the real issues in the case. But at the bottom end, there are rear end shunts, low velocity rear end shunts, changing lanes on roundabouts, where there's potential for a claimant to be found fundamentally dishonest, but it's not really necessarily the driving force in the case. For those types of cases, it might be that the parties can agree that although it's a possibility that the issue isn't going to be pursued by the defendant should the judge find that the claimant's evidence is not sustainable. Because we've all had cases, haven't we, in this area where a claimant's evidence is poor and the defence advocate then has a decision to make as to whether they say to the judge, well, that evidence is so poor you simply can't rely on it and I invite you to dismiss the claim. Or it's so poor that pulling all the strings together, you can find that that claimant has lied to you. And if that claimant's lied to you on a number of different areas in their evidence, then therefore it's fundamental dishonesty. There might be a possibility, in my view, where if you are keen to get the case heard, and if you're defending, you are more concerned about defending the case as opposed to getting what is ultimately probably an unenforceable costs award. You might say, look, we will raise the issues that we've dealt with in the defence or in correspondence or in the witness evidence in terms of the claimant's credibility, but we will not make an application for a finding of fundamental dishonesty. To my mind, that will allow a judge to consider a witness's or a claimant's credibility It will allow the judge to make findings, if necessary, that there have been some untruths. It will allow the judge to dismiss the case, but importantly, it will protect a claimant from a finding of fundamental dishonesty, which for all sorts of people can have fairly significant impacts on their lives. These are just my thoughts, having considered the order from Manchester in relation to trials that are coming up. But it's certainly something which is worth looking at if you are a litigator who has a backlog now of trials and you're considering that you need to get your trials on, and you can do so in a way that doesn't prejudice your client's position. So if you're the claimant, there are some advantages there, aren't there? If there's a case that has fundamental dishonesty in the background, you can run that case knowing that there's no adverse costs consequences. If you're a defendant, you can run that case knowing that you have a chance to succeed, and there is an opening for the judge to find in your favour, as long as you're willing to sacrifice the finding of fundamental dishonesty, and that will be a matter between you and the insurer. So that's just something to consider when the courts are asking, and will inevitably ask wherever you are, what the issues in the case are, and whether the issues are so serious that it would be unjust to hold a hearing remotely.